I would like to thank all the organizers for inviting me to this platform. This is our second webinar, and my objective for today as a co-speaker with Annalise is to share some information with you, information related to the national mechanisms for the defense of human rights. I will run a very short presentation, which will be a logical continuation of what Annalise delivered to you. And then I will talk more about how decisions are made of or how rulings are issued on various complaints by various international mechanisms on human rights and how such decisions and rulings and recommendations are implemented in the Kyrgyz Republic. Speaking of national mechanisms, we talk about state mechanisms that exist in our country that are aimed at protecting human rights and freedoms. And national mechanisms or state-supported national mechanisms, here we can add the so-called public or state mechanisms for the protection of human rights. I'm going to talk about NPM, the National Preventative Mechanism, because NPM is a very unique, specific state-supported institution, which is an animal in its own right. So now, however, we're talking about two major blocks, which is the judiciary protection. The other one is the non-state human rights defense mechanisms. So let's go over in a greater detail over both blocks and what their roles and duties are. So the first one being the judicial protection. So the judicial protection is ensured via the within the judiciary, we have the constitutional court, the civil court, the criminal code, and the administrative court. In other words, as part of these judicial proceedings, human rights and freedoms are protected or ensured. The role of the judiciary is pretty wide, if you will. First of all, is to prevent the violations of human rights. When during certain court proceedings, we have precedents emerging, right? Or judiciary practice that pretty much provides judicial mechanisms that help prevent future human rights violations. The second one being the restoration or recovery of rights violated. When individuals who are victims of human rights violations, the role of the judicial system, again, is to prevent human rights violations. The second one is to recover, help the restoration of human rights. When the judiciary pretty much responds to human rights violations and helps restore victims of human rights. Those individuals who believe that their rights were infringed upon may address the court of law to have their rights restored, basically a recourse. The third role of the judiciary is to repeal those legislative acts that contradict other major superior laws. And here, this role of the judiciary, we're talking about those state bodies that have the right to make laws. And when they make such laws, and when they make laws that violate human rights, this is when the courts respond to them. Especially, say, for instance, when a certain bylaw or regulation is in contradiction or in violation of a superior law, or when a certain law is in contradiction with a code or the Constitution. So, in other words, we're talking about ensuring about how the judiciary ensures that the legislative branch does not adopt laws that violate the Constitution. So this is a checks and balance issue. The next role is to restore punitive damages and the restoration of rights or compensations. So whenever individuals become victims of human rights violations, this normally sometimes entails some kind of damage, emotional damages, financial damages, punitive damages. So the judiciary, in addition to restoring rights violated, performs the role of ensuring that there is some kind of restitution, financial restitution of rights violated. And last but not the least, and which is still very important, the judiciary rules on what kind of liability should entail for those perpetrators of human rights violations. That's exactly the rule of law, which we touched upon during the previous webinar, because this rule of law is ensured by the judiciary. When the judiciary holds perpetrators liable, the legislation and those standards in human rights are only operational when the government ensures, the government as in all three branches of the state, when the government ensures the principle of violations of human rights immediately and always entailing some kind of liability, some kind of punishment that not only is needed to restore human rights, but also to prevent their violations in the future. So, what is the advantage of the judiciary, of judicial mechanisms for the protection of human rights? Well, this mechanism has a lot of advantages, actually. The first and foremost being the independence of the judiciary. Of course, speaking of independence of the judiciary, there are a lot of questions because pursuant to standards, of course, the judicial branch of the government should be independent. In reality, in practice, however, the situation differs, especially independence could be true and real, or independent could be nominal or partial. Independence of state actors, because remember, the judicial system does not have its own program of, say, like any other state body, unlike the executive bodies that implement a certain function. So the executive branch executes its own programs, and to judge whether or not or how well it is doing its job, here we have this agency-specific interest, a corporate interest, while the judiciary should be free of corporate interest. As to the publicity, well, it's self-explanatory. The judiciary has to be open, transparent. People should know how the judicial system works, and we know that as per standards, the majority of court rulings or court hearings and proceedings must be open, apart from a very narrow list of those cases that can be heard behind closed doors, say, in order to protect national interest issues, or to protect certain rights and freedoms of other individuals, such as the minors, underage people, victims of violence, etc. Now, one of the advantages is that the judicial system studies immediately studies the evidentiary basis, the facts that both sides present. That's very important because court rulings are based on specific pieces of evidence submitted procedurally by both parties to a lawsuit. Equal opportunities, that the principle of equal opportunities of both parties is very important because either party may decide to participate in a proceeding, present its arguments, reasoning, and the court or the very procedure of court proceedings is based on the following principle. Say, without the knowledge of a victim or the plaintiff or the defendant, without their knowledge, the court must not issue any ruling. So the court must provide both the defendant and the plaintiff with an equal opportunity to defend themselves. It is also important that rulings, of course, must be binding for all state bodies, not only for for that matter, not only for state bodies, but also for all organizations and institutions, for all individuals involved. Additionally, and that's very important, the courts make rulings that immediately entail the procedure of the restoration of rights infringed upon, or the right to receive restitution for their violated rights. In other words, a ruling by any court is sufficient in order for any state body or any executive body or for the Ministry of Finance to initiate the process of the payment of a restitution for rights violated. There is also a very clear procedure that pertains to how the judicial system works. For instance, both parties may go through various tiers of courts when you can appeal a ruling by the subordinated court, and the Supreme Court as the ultimate ruling body, whose ruling is not subject to an appeal. In other words, there is a principle of the fact that this process is finite, that it can not go into an eternity. Although, yes, we do see in reality very protracted court proceedings when the very same lawsuit is being considered for years. That is exactly an example of when we have such a judicial wheel spinning, if you will, from the international perspective, that could be considered an ineffective mechanism and a violation of the right to fair trial. When the international community can prove that there is will spinning by the judicial system. So yes, there is a function of appeal to a certain degree.
So there is a certain procedure when decisions are final. And this has to do with judicial protection. Now, the next one that I would like to talk about is parliamentary protection. This is extrajudicial. Within the extrajudicial, what's important is parliamentary protection. And the role of parliamentary protection is so mainly the parliament is adopting laws and developing laws on human rights. So at the last webinar, those of you who participated, we said that your national standards on human rights, although based on our constitutional norms, it says that your national agreements are ratified by the Kyrgyz Republic, ratified by Kyrgyzstan, they are an integral part of our legal system. Regrettably, in practice, what we can see is your national law or your national conventions or agreements, these provisions and norms do not have
И, соответственно,
they
то есть
cannot
вот
be applied directly in the country. So this process, when a certain international standard on human rights, when it has to be integrated in national legislation, Kyrgyz legislation, this is an important process. And that's the role played by the parliament. When the parliament adopts a certain law or adopts codes, and they are making sure that your national standards on human rights, those that we also have in our constitution, and this is what's enshrined in your national documents, all of them should be integrated in the legislation of Kyrgyzstan. And the second function that the parliament has, that's called parliamentary control. So parliamentary control, that's pretty much, let's say, this can be a very effective thing when members of parliament, when they can look at the situation on human rights and monitor the situation on human rights and respond. And in this context, both the parliament or parliamentary committees, they may create or set up commissions, ad hoc commissions,
контроль над
and these
деятельностью
commissions may implement parliamentary control over the activities of certain state bodies or based on certain topics or areas. So once again, in order to invest efforts in ensuring human rights or in complying with the legislative norms that the parliament adopts, or they monitor the implementation of a certain state program on human rights. And parliamentary control, it can be, like I said, can be a very effective tool in certain aspects or on certain specific rights that, let's say, members of parliament are interested in, or within the framework of, let's say, their priorities, or based on the priorities of certain committees.
несудебная система.
Now, the third one, extrajudicial, that's prosecutorial supervision. Prosecutorial supervision as a human rights mechanism is highly important in terms of the functions of the prosecutorial office, which is set forth in the law on prosecutorial offices. And what they do is supervise the implementation, the uniform implementation of Kyrgyz legislation. And as if we build this logical link, the parliament that adopts a law in accordance with international standards on human rights. So now prosecutorial agencies, they are responsible for having this law implemented precisely by other state institutions or other bodies, so by other public officials, both national authorities or local authorities, and so on. And moreover, prosecutors' offices, they're also in charge of supervising the implementation of laws. So anything relating to special investigation activities or anything relating to investigation, basically the law enforcement system. They supervise the work of the law enforcement system. And
права, в том
because
числе
once again, there are certain individual rights and the absolute rights, like the right to freedom from torture and cruel, inhuman, and degrading treatment and punishment. So in practice, what we see is that law enforcement bodies are one of those structures that, let's say, violate these specific rights more than others. So therefore, we need a prosecutor's offices in order to make sure that human rights are fully adhered to and respected by the law enforcement system. Besides, we also have some issues relating to the supervision over the implementation of laws while working on judicial decisions. So the major function, the representative function in courts when prosecutorial agencies, let's say, when they represent certain interests. And besides, the prosecutorial offices have this function of sustaining the state accusation in court. So they support state accusation. Also, when we say that the function of protection, including any obligations on protecting human rights for persons who suffer from human rights abuses, the prosecutorial offices, they play this function from outside. And the next one, this is when prosecutorial agencies have the right to initiate criminal proceedings. So of course, now, based on the most recent amendments, this function is no longer there, but the prosecutorial agency may initiate criminal proceedings on human rights violations and to instruct to those bodies to bring all those public officials who violate human rights to justice. And except for military crimes, because then we have a special military prosecutors offices that are in charge of military crimes. Now, speaking of, let us proceed. And now this is the Ombudsman's institution as one of the systems and aspects of human rights protection. And this is a subdivision of parliamentary control, if you will, since the Ombudsman's office and the Ombudsman himself or herself, they play one of the functions of parliamentary control. So they conduct monitoring, human rights monitoring, and on an annual basis, they provide reports to the parliament. But the functions of the Ombudsman's office or Ombudsman's institution, if we look at them, this is about protecting human rights and freedoms, which are once again enshrined in the Constitution and set forth in international standards, thus respecting the rights and freedom, human rights and freedoms, prevention of human rights violations and abuses. This is when, through the monitoring system, the Ombudsman's office may prevent certain human rights violations. That's also facilitating bringing the legislation, human rights legislation, in line with the Constitution. So when the Ombudsman's office may initiate, once again, since this is a part of the parliamentary control, through providing their recommendations to the parliament, they may initiate certain amendment in legislation which maybe violates human rights. So now improving and further developing international cooperation, prevention of any types of discrimination, and also facilitating the public to receive more information and to building public awareness. And the role of the ombudsman may be highly important in building the capacity and raising awareness of all state institutions that in one way or another play the role of the state body and that protect human rights and freedoms. So as I can see here, we have already some questions. Do we have questions? Let me first finish, and then I will try to answer all of the questions and comments that you have made here. Now, as part of the extrajudicial aspects, the administrative and legal protection. So in fact, most of state institutions based on their functional duties, certain ministries and agencies and state agencies, in one way or another, they play the function or the role of the state body, and they have to comply and respect human rights as a state's obligation. This is exactly what we spoke about at the previous webinar, and specifically the other speaker spoke about it. She was saying that within each human right, there are three major types of obligations, right, that the state has. So respecting and protecting human rights and ensuring the protection. So within these functional duties, the state does it through its executive bodies. And when we see that there is a certain violation on the ground, that human rights are violated, then people have the right to apply to seek protection within the administrative body, so they can apply to higher level bodies for the specific body that they're applying to, that to redress the situation. All right, so now this is speaking of administrative and legal protection. So the reason I did not talk about NPM as a separate, there was a question about NPM, the National Preventive Mechanism, NPM. Yes, indeed, it is an effective instrument. It is a facility, a human rights institution. It is an effective state institution that works toward preventing torture. And here, because once again, we are discussing general mechanisms on a very broad range of human rights. So I did not speak specifically about the NPM, but the NPM in the Kyrgyz Republic, so maybe many of you are familiar with, this is a state body that has the right to conduct monitoring of all closed penitentiary facilities with respect to respecting the absolute right again on the freedom from torture and cruel, inhuman, degrading treatment. So within their activities on monitoring, they also have certain functional duties. And first of all, we talk about redirecting or cases, or describing the situation, ensuring the respect for their right to freedom from torture. This information is sent to state bodies for them to redress the situation. And also annually, they provide a very broad analysis and provide reports to the parliament on the situation relating to torture. So once again, this is only one right that we're talking about, freedom, right to freedom from torture. And so I would like to also specify non-state mechanisms of human rights protection.